Thank you for being here and watching this video. If you enjoy it, please like, subscribe, and leave your thoughts in the comments. I want this channel to be more than just a collection of videos. I want it to be a community where we explore fascinating ideas, discuss them openly, learn from one another, and grow together. So don't stay silent, join the conversation. Literature has always been more than storytelling. At its core, it functions as a parallel institutional system, one that observes, audits, and occasionally dismantles the logic of formal governance. Legislative criticism in literature is precisely this function. The systematic questioning of laws, legal institutions, and the moral architecture behind them through fictional or poetic form. This isn't done romantically or emotionally, it is done structurally. Writers act as adversarial interpreters, stress testing the narrative framework of the law to see if it holds up under the weight of lived experience. While a statute may look perfectly rational on paper, literature asks the uncomfortable question: what happens when this rule collides with the messy, unpredictable reality of human life? The result is often not immediate legal reform, but a profound cognitive dissonance that forces us to see the law for what it truly is: a constructed story. Every legal system is, in essence, a narrative system. It defines what counts as truth, responsibility, guilt, and legitimacy. Literature steps in to challenge these definitions. When we look at the classical roots of legal critique, we see this pattern repeating across history. In ancient Greek tragedy, the law is frequently portrayed as rigid, unyielding machinery failing against the crushing weight of moral complexity. In medieval narratives, we see the constant collision between divine law and human law, exposing the contradictions in earthly authority. By the Enlightenment, writers began explicitly interrogating state power, bureaucracy, and institutional hypocrisy. Literature became a pressure-testing environment for legal systems that claimed to be universal, but were often deeply parochial or flawed. It creates a space where the letter of the law is interrogated by the spirit of the human. In the modern shift, the focus of legislative criticism has moved from individual laws to entire systems of governance. Instead of asking, "Is this law fair?" modern and postmodern literature increasingly asks, "Who benefits from the structure that produced this law?" What forms of suffering are normalized by legal neutrality? Where does accountability dissolve inside the vast machinery of bureaucracy? This is where legislative criticism merges with political philosophy. Law is no longer viewed as a neutral instrument for justice, but as an extension of power architecture. It is a tool used to define who is inside the protection of the state and who is outside its boundaries. Literature exposes the psychological and existential effects of these structures, particularly when the antagonist is no longer a person, but an abstract force like a procedural loop or an administrative hurdle. Modern literature often replaces the traditional villain with bureaucracy. This is not accidental. Bureaucracy represents law without moral visibility, decisions made without identifiable decision makers. Literature exposes the nightmare of justice, delayed into irrelevance, and responsibility diffused across systems until it entirely disappears. In these fictional worlds, individuals are trapped in procedural loops where no one is responsible, making everyone technically innocent but practically unaccountable. The critique is subtle but effective. It highlights how the system protects itself by making its operations so complex that they become invisible. Literature forces this invisibility into the light, making the unregulated audit layer of the legal ecosystem visible to the public eye. From a functional perspective, literature operates like a simulation engine for legal theory. It allows us to explore edge cases that laws were never designed for, and moral paradoxes that statutes simply cannot resolve. Unlike a court of law, literature does not need a resolution. It can leave contradictions open, unresolved, and structurally uncomfortable. That is its unique analytical advantage. It doesn't have to provide a verdict. It only has to provide a witness. By doing so, it provides a non-institutional feedback loop that is not bound by precedent, jurisdiction, or procedural admissibility. It can say what legal discourse often cannot afford to say explicitly. It challenges the self-referential nature of legal systems, ensuring they are optimized for justice rather than just internal consistency. Ultimately, legislative criticism in literature is not rebellion in the dramatic sense. It is something more sustainable and more dangerous to complacency. Continuous interpretive pressure. It does not overthrow the law through force. It questions its assumptions until they become visible again. In that visibility, the law is forced to justify itself, not as an absolute authority, but as a system of reasoning. That is where literature quietly wins its case. It reminds us that the law was made for humans, not humans for the law. To understand how fiction audits the law, we must look at the specific mechanisms it uses to conduct this legislative simulation. One of the primary tools is the extreme case, or the moral outlier. While laws are written to cover the majority of social interactions, they often fail spectacularly at the margins. Literature gravitates toward these margins. By placing a character in a situation where the law demands an action that is clearly immoral, or where the law offers no protection against a clear injustice, fiction forces the reader to confront the inadequacy of the statute. This is the stress test. If a legal principle cannot handle the extreme case, literature suggests that its claim to universal validity is a myth. This creates a bridge between the abstract code and the concrete human consequence. Another mechanism is the deconstruction of legal language. Legal systems rely on precise, often exclusionary language to maintain their authority. Literature, with its focus on ambiguity, metaphor, and subtext, peels back these linguistic layers. It shows how words like reasonable, legitimate, and evidence can be manipulated to serve power rather than truth. By rewriting legal scenarios in poetic or narrative prose, writers expose the narrative gap between what the law says it is doing and what it is actually accomplishing. This linguistic audit is crucial because it challenges the law's monopoly on the definition of reality. It asserts that there are truths that cannot be captured in a legal brief and sufferings that cannot be quantified in a settlement. This leads us to the role of the moral witness. In a legal system, a witness is someone who provides facts to help the court reach a verdict. In literature, the witness is someone who provides the emotional fact of the law's impact. By focusing on the victims of legal neutrality, literature gives a voice to those whom the system has rendered silent. It challenges the idea that a law is good simply because it is applied equally to everyone. As many writers have noted, the law, in its majestic equality, forbids the rich as well as the poor to sleep under bridges. Literature highlights this irony, showing that neutral laws can produce highly biased outcomes. This function of literature serves as a critical feedback loop for a society's moral evolution, ensuring that justice remains a pursuit rather than a settled state. The shift from individual laws to systemic power in postmodern literature has introduced the anonymous system as a central theme. In these works, the law is not a set of rules you can follow to be safe. It is a landscape you must navigate to survive. The villain is not a corrupt judge or a wicked legislator, but the very process of seeking justice itself. This reflects a modern anxiety, the feeling that we are governed by algorithms and administrative codes that no one person fully understands or controls. Literature acts as the black box recorder for this system. It captures the psychological toll of living in a world where the law is omnipresent, but justice is elusive. It documents the erosion of the self under the pressure of constant, invisible regulation. Why does this legislative criticism matter for the average person? Because it prevents the law from becoming a dead language. A legal system that is not constantly interrogated by its culture eventually becomes a relic, a set of rituals that serve the past rather than the present. Literature provides the unregulated audit that keeps the law honest. It reminds the practitioners of law, the judges, lawyers, and legislators, that behind every case file is a human life. It forces the public to take responsibility for the laws enacted in their name. By turning legal questions into narrative problems, literature makes the law accessible, debatable, and ultimately reformable. It ensures that the law remains a tool for human flourishing rather than a cage for the human spirit. In conclusion, the quiet function of literary dissent is to ensure that the law never stops being a reasoning process. It forces the law to explain itself to the people it governs. Fiction doesn't need to pass new statutes to be effective. It only needs to change how we think about the ones we already have. When a book makes us realize that a certain law is absurd, or that a certain institution is soul-crushing, the first step toward change has already been taken. The unregulated audit of literature is the safety valve of a democratic society. It is the voice that says, wait, this doesn't make sense, even when the entire weight of the state says it does. That voice is the difference between a society governed by laws and a society governed by justice. Thank you for watching all the way through. I really appreciate you being here. Let me know what you think about the ideas in this video, and feel free to share your own perspective or advice in the comments. I genuinely like to read it. If you enjoyed this kind of content, please like the video and subscribe. My hope is to build not just a channel, but a community where people explore meaningful ideas, exchange thoughts, and grow together. See you in the next videos. Bye.